If you carry a concealed firearm and you've ever wondered whether you're breaking the law just by walking into a grocery store or a gas station with it on you, a Supreme Court ruling from this past June directly answers that question. And it just reversed the rule in 5 states at once. On June 25, 2026, the Supreme Court ruled 6-3 in a case called Wolford versus Lopez, striking down a Hawaii law that required concealed carry permit holders to get explicit, affirmative permission from a property owner before bringing a firearm onto private property open to the public, everything from a restaurant to a pharmacy to a dry cleaner. Before this ruling, in Hawaii and 4 other states, the default legal assumption was that you couldn't carry into an ordinary business unless that business specifically posted a sign welcoming firearms. This ruling flipped that default completely. Gun rights advocates had nicknamed Hawaii's rule the vampire rule because, just like the old folklore about vampires needing an explicit invitation before they can enter a home, permit holders needed an explicit invitation before they could lawfully carry into an ordinary business, a nickname that stuck precisely because it captured how unusual and impractical the rule felt in daily life. I'm going to walk you through exactly what Hawaii's law required, why the Supreme Court found it unconstitutional, what the dissenting justices warned about, and what this means if you carry in one of the states this ruling directly affects. Before we get into it, if you want legal breakdowns that explain the actual reasoning behind a ruling instead of just repeating the outcome, subscribe and turn on notifications right now. This is exactly the kind of case with real, everyday practical consequences for millions of permit holders, and understanding both sides of the legal argument matters if you want to actually know your rights rather than just assume you know them. Let's get into exactly what Hawaii's law said and why it collapsed under Supreme Court review. Here is what Hawaii's law, formerly known as Act 52, actually required, because the specific mechanics matter enormously to understanding this case. After the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruin established that the Second and 14th Amendments protect a right to carry handguns outside the home for self-defense, Hawaii responded by passing a new law governing where permit holders could actually carry once they had a permit in hand. Under the traditional common law approach that governs property in most of the country, a business open to the public is presumed to allow entry, including entry while carrying a lawfully possessed firearm, unless the owner specifically posts a sign or otherwise indicates firearms aren't welcome. Hawaii's law reversed that default entirely for concealed carry permit holders specifically. Under Act 52, a permit holder committed a crime by carrying a firearm, even one that was unloaded or completely inoperable, onto private property open to the public, unless the property owner, lessee, operator, or manager had given express affirmative authorization first. 3 Maui County residents, each holding a valid concealed carry permit, along with the Hawaii Firearms Coalition, challenged the law in federal court in 2023, arguing it was unconstitutional. The case worked its way through the lower courts on a path worth understanding, because it shows just how contested this specific legal question already was before it ever reached the Supreme Court, and how differently federal appeals courts across the country had already begun answering essentially the same question. A federal district court in Hawaii agreed with the permit holders and enjoined the law as applied to private property open to the public, finding it likely unconstitutional. A panel of the Ninth Circuit Court of Appeals reversed that decision, siding with the state, and when the full Ninth Circuit declined to rehear the case with its entire bench, the permit holders petitioned the Supreme Court for review, pointing specifically to a direct conflict between the Ninth Circuit's ruling and a contrary decision from the Second Circuit on essentially the same legal question, a circuit split that made this exactly the kind of case the Supreme Court typically steps in to resolve. The first segment of this story is the practical burden the Supreme Court found this law actually imposed, because the majority opinion spent real time walking through exactly how this rule played out for an ordinary permit holder going about an ordinary day. Justice Samuel Alito, writing for the majority, described how a single day of routine errands, stopping at a gas station, a restaurant, a drugstore, a dry cleaner, and a grocery store, could expose a completely law-abiding permit holder to criminal liability at every single stop, unless every single one of those businesses had specifically and affirmatively posted signage welcoming firearms, something the vast majority of ordinary businesses simply never do one way or the other. The court found this reversal of the traditional default rule imposed what it called a new and significant burden on the right to carry a firearm for self-defense, one that functionally made lawful carry impractical across huge portions of daily life for permit holders, since most businesses post no signage on the subject at all, leaving permit holders with no reliable way to know in advance whether entering with a concealed, lawfully carried firearm was a crime or not. The practical absurdity the majority highlighted was straightforward. A permit holder who had gone through Hawaii's own licensing process, passed a background check, and received official state authorization to carry could still be committing a crime the moment they stepped into an ordinary pharmacy to pick up a prescription, entirely because that pharmacy had never bothered to post signage on an issue. Most business owners never think to address one way or the other, turning an entire population of licensed, vetted carriers into unwitting lawbreakers through simple business owner inattention, rather than any deliberate choice by the property owner to exclude firearms. The second segment is the legal framework the court applied to reach that conclusion, because this case is part of a broader pattern that's been unfolding since 2022. Every Second Amendment case since Bruin has to go through a specific two-step historical analysis. First, courts ask whether the challenged restriction touches conduct the Second Amendment's text presumptively protects. The court found this step easily satisfied here. The permit holders were part of the people the amendment protects, they sought to bear arms, and Hawaii's law imposed a real, significant new burden on that right. Second, and this is where the real legal fight in Wolford happened, the government has to show the restriction is consistent with the nation's historical tradition of firearm regulation, meaning Hawaii had to point to comparable historical laws from the founding era or the period around the 14th Amendment's ratification that imposed a similar kind of burden for a similar reason. Hawaii's strongest historical argument centered on old laws restricting carrying weapons on someone else's land without permission. But the court found these historical analogs, several of which the court noted actually originated in trespassing and unauthorized hunting statutes, rather than anything related to self-defense in public commercial spaces, weren't relevantly similar enough to justify a modern rule reversing the default for firearms, specifically while leaving every other kind of lawful conduct on private property governed by the traditional opposite default rule. This distinction between old laws aimed at protecting rural landowners from unauthorized hunters wandering onto their acreage and a modern rule aimed at ordinary urban and suburban commercial establishments open to the general public became a central sticking point in the majority's analysis. Since the underlying purpose and practical effect of the two kinds of laws are genuinely quite different, even though both involve restricting where someone can carry a weapon on land they don't own. The third segment is a specific historical argument Hawaii raised that the court addressed directly and rejected in unusually pointed language. Hawaii's defense pointed to a statute connected to Louisiana's Black Code, a set of laws from the post-Civil War South designed to restrict the rights of newly freed Black Americans. The court's opinion was notably blunt in dismissing this particular historical analog, stating that Hawaii's reliance on what the opinion called a tainted artifact of this specific historical period could not be taken seriously as evidence of the original understanding of the right to keep and bear arms, adding that even setting aside that history, the specific law wasn't widespread or widely accepted enough at the time to count as part of the genuine historical tradition the Bruin framework requires. This specific passage became one of the most quoted parts of the opinion precisely because of how directly the court rejected using that particular piece of history as a legal foundation, a rare moment of genuinely sharp, almost rebuking language in what was otherwise a fairly technical, methodical, historical analysis, running across more than 20 pages of the opinion. Legal commentators on both sides of the broader gun rights debate noted this specific passage afterward, some praising the court for refusing to let a law rooted in racial oppression serve as precedent for a modern gun regulation regardless of the underlying policy debate, others pointing out that the passage illustrates a broader, ongoing challenge with the entire historical analogy framework, namely, that the specific laws available from certain historical periods are not evenly distributed across every possible policy question, sometimes leaving states with genuinely thin or genuinely troubling historical source material to work with when trying to satisfy the Bruin test. The fourth segment is what the concurring opinion added to the majority's reasoning, because it reveals some additional nuance about exactly how far the ruling's logic extends. Justice Amy Coney Barrett wrote a separate concurring opinion, joined in part by Justices Thomas and Gorsuch, adding additional analysis to a specific section of the reasoning. While concurrences don't carry the same binding weight as the majority opinion itself, Barrett's partial concurrence signals that, even among the 6 justices in the majority, there were some differences in exactly how each justice approached specific pieces of the historical analysis, a detail worth knowing if you're trying to understand exactly how lower courts are likely to interpret and apply this ruling's full reasoning in future cases involving similar but not identical property rules. The fifth segment is what the dissenting justices actually argued, and their position deserves to be presented fairly because it reflects a genuine and serious set of concerns about property rights and public safety, not simply opposition to gun rights as a general matter. Justice Elena Kagan wrote a dissenting opinion, and Justice Ketanji Brown Jackson wrote a separate dissent joined by Justice Sonia Sotomayor. The dissenting justices argued that Hawaii's law reflected a legitimate exercise of the state's traditional authority to regulate the terms under which people access privately owned property, pointing out that property owners have always had broad authority to set conditions on who enters their premises and how, and arguing that requiring firearms specifically to get affirmative permission, rather than defaulting to allowed unless posted otherwise, was a reasonable, modest adjustment to that traditional authority given the unique safety considerations firearms present in its densely populated commercial spaces. The dissent also raised concerns about the practical burden on small business owners, who, under the majority's new default rule, must now affirmatively post a sign specifically prohibiting firearms if they want to exclude them. A burden, the dissent argued, shifts real costs and real decisions onto individual business owners who may not want to take a public position on the issue either way, whereas under Hawaii's law, the state itself had made that default decision for them. The dissent further argued that many small business owners, faced with the choice of posting a visible no firearms sign or remaining silent and thereby implicitly permitting carry, might feel pressured into taking an unwanted public political stance simply by virtue of the majority's chosen default rule. A dynamic the dissenting justices suggested Hawaii's original approach had specifically avoided by placing the affirmative burden on the state's regulatory framework rather than on individual proprietors navigating a potentially contentious issue with their own customers. The sixth segment is what makes this ruling immediately significant beyond Hawaii itself, because the legal reasoning directly threatens similar laws already on the books in several other states. Legal analysts tracking this case identified California, Maryland, New York, and New Jersey as states with comparable laws requiring some form of affirmative permission before concealed carry permit holders can bring firearms onto private property open to the public. Those laws all passed in some form after the 2022 Bruin decision as part of a broader wave of state legislative responses attempting to define where the newly recognized right to carry could actually be exercised, now face significant new legal vulnerability under the exact reasoning the Supreme Court just applied to Hawaii's version. New York's law emerged from that state's own legislative response to Bruin, part of a broader package sometimes referred to as the Concealed Carry Improvement Act, which included a similar default to prohibited rule for private property open to the public, alongside various other carry restrictions. California and New Jersey enacted comparable provisions around the same period, each responding to the same underlying legal landscape Bruin created, and each choosing a broadly similar regulatory approach, restricting carry on private property absent the owner's affirmative consent. Attorneys and advocacy groups on both sides of this issue expect a wave of new litigation challenging these other states' similar laws in the months following Woolford, using this decision as the controlling precedent, and several organizations that were already involved in litigation against these other states' laws before Woolford was even decided have indicated they intend to move quickly, filing new briefs and motions citing the Woolford opinion directly in their ongoing cases. The seventh segment is what this ruling does not do, because it's important to understand the actual limits of what changed here, separate from the practical significance of the holding itself. This ruling addresses the specific question of private property open to the public, meaning ordinary businesses and commercial establishments that welcome the general public onto their premises. It does not address, and the opinion does not purport to resolve, questions about carrying on genuinely private residential property, or in the many categories of sensitive places, government buildings, schools, and similar locations that remain restricted under separate legal doctrines the court has addressed in other cases entirely. Property owners, including business owners, retain the full ability to prohibit firearms on their premises. What changed is simply which side bears the burden of making that choice known. The business owner now has to affirmatively post a sign to exclude firearms, rather than the permit holder needing affirmative permission to carry one in. It's also worth being clear that this ruling doesn't touch the underlying permitting process itself, meaning whatever requirements your state imposes for actually obtaining a concealed carry permit in the first place remain completely separate from this specific question of where, once you have a valid permit, you're allowed to carry it. And the ruling doesn't create any new right to carry into a private home without the resident's consent, since a residence has always been treated as categorically different from a commercial establishment open to the general public, a distinction the majority opinion did not disturb in any way. Let's step back and name the single thread running through this entire case. This was fundamentally a dispute about who bears the burden of uncertainty when a state tries to regulate where a newly recognized constitutional right can actually be exercised in daily life. Hawaii's law placed that burden on permit holders, who had to somehow determine, business by business, whether they had affirmative permission to carry before they could safely enter. The Supreme Court's majority found that burden constitutionally significant enough, and historically unsupported enough, to strike the law down, restoring the traditional default rule that governs virtually every other kind of lawful conduct on private property open to the public. The dissenting justices saw the same situation differently, viewing Hawaii's law as a legitimate, modest adjustment to how private property access works specifically for firearms, given the unique safety considerations they present. Both positions reflect genuinely held, serious views about how property rights, public safety, and an individual constitutional right to bear arms for self-defense should intersect in ordinary commercial spaces, and the 6-3 split, while not as dramatic as a unanimous ruling would have been, reflects a real and substantial disagreement among the justices about exactly where that balance belongs. It's worth sitting with the deeper tension this case reveals because it goes well beyond just guns specifically. Property rights and the rights of the people who use that property have always existed in a kind of ongoing negotiation, one that shifts depending on how open a piece of property is to the general public, how significant the right being exercised on that property is, and how much practical burden falls on ordinary people trying to navigate the resulting rules in daily life. A business open to the public occupies a different legal space than a purely private home precisely because the owner has voluntarily invited the general public in, and courts have long grappled with exactly how much control that owner retains over the terms of that invitation once extended. Woolford v. Lopez answers that question specifically for firearms and specifically for the Second Amendment, but the underlying tension between an owner's control over their own property and the practical rights of people using property the owner has opened to the public shows up across a wide range of other legal contexts entirely. From disability access requirements to anti-discrimination law to zoning disputes, none of which this ruling directly addresses, but all of which share the same basic structural question at their core. If there's one thing worth taking from this breakdown, it's that a ruling addressing something as seemingly mundane as store-by-store carry rules can carry enormous practical weight for millions of ordinary permit holders going about ordinary days, and that the legal reasoning behind a ruling like this one is now actively being deployed against similar laws in several other states, meaning the practical impact of Woolford v. Lopez is likely to keep expanding well beyond Hawaii's borders in the months ahead. Understanding both the specific holding and its real limits is the difference between actually knowing what changed on June 25, 2026, and just repeating whichever oversimplified version of the story you happen to see first. If this helped you understand a ruling that could genuinely affect your own daily carry decisions, share it with someone who carries and travels between states. Subscribe so you catch the next major ruling the moment it's actually explained accurately, and I will see you in the next one.